Hello everyone, welcome to BYD Classes, and this will be the fifth lecture of Indian Polity Mains 365 2023 for Mains UPSC Mains 2023 examination. So let's begin. So here we will understand the Parliament and State Legislature section, and what is the structure and functioning of the Parliament and State Legislature. So under this, the first was in news the separation of power. Recently, demand of the executive representation in collegium system had started debate over doctrine of separation of power in Indian constitutional setup and why importance of separation of power for protect rights and liberty of citizens. So what is liberty and what is rights? So you can watch my video for the Indian polity section that will be delivered since 10th of October 2023. Okay. So under this, the protection rights and liberty of citizens, for example, Supreme Court in K.S. Puttaswamy case versus Union of India case reaffirmed the right to privacy as a fundamental rights, and it was also the committee headed by B.N. Sri Krishna committee in 2017. Okay. And distribution of powers leads to limited powers with each organ, thus prevents rise of dictatorship or anarchy and promote constitutional supremacy, and creates functional specialization among different institutions, ensuring efficiency in governance or government, and minimizes conflict among government institutions. Okay, and it ensures the judicial independence, and separation of powers is also promote the independence of judiciary. Okay, so here it is given. And what are the issues in separation of power in India, such as challenges in division of function? Under this issue, challenges in division of functions, doctrine assumes that three functions of government are independent and distinguishable from one another. However, in practice, there can be an overlap in their functions and powers, leading to conflicts and challenges in adhering to separation of powers principles. For example, if legislature can only legislate, it may face difficulties in punishing someone who commits a breach of its privilege, as it could be seen as a quasi-judicial function, which are being seen recently. Parliament and Supreme Court, as well as any other courts of India, leads to encroachment of other organs, such as center interferes the judicial organs, judicial cases, and judiciary interferes the center's cases. Okay, that modern interpretation of doctrine recognizes incidental functions by one organ without encroaching on essential functions of another. However, there is a risk of encroachment leading to power struggle, undermining the principles of separation of powers, and practical difficulties in its acceptance that the center is accepting the Supreme Court judgment, like in recent case Union Territory of Delhi amendment to the services or the governance of Delhi government. Okay, and it and governance or ordinance was passed by the state legislature, sorry, by the parliament. And in March 2023, Supreme Court given the power to the state legislature of Union Territory of Delhi and declared that the government of Union Territory of Delhi has the power under the service condition. Okay, so here the tussle between the government and judiciary. So government of India overruled judicial interpretation that ordinance making power of the parliament is valid, and ordinance making power of the parliament is the case of the parliament and not the union territory of the Delhi government. So here the political difficulties in its acceptance. In practice, it has not been found possible to concentrate power of one kind in one organ only. And the next issue is the legislature does not act merely as law-making body, but also act as an overseer of the executive. The administrative organ has legislative functions, such as government passed more laws through the money bill instead of discussion in the parliament or any private or government member bills. And judiciary has not only judicial functions but also has some rule making powers. What are the constitutional provisions related to separation of powers? Under Article 13 mention the judicial review, which is taking under the law. And here, if any law passed by the parliament and it violates, the law violates wherever possible, the law violates which are given under Article 13, the Supreme Court shall declare null and void. And any law passed under Article 368 and if it violates the law under given Article 13, then Supreme Court shall declare null and void. So remember this. And Article 32 and Article 226, the power given to the right to constitutional remedies under Article 32, which is under the jurisdiction of Supreme Court, and Article 226, which is under the jurisdiction of the High Courts, and Article 50, which is separation of power between the judiciary or direct separation of power from judiciary or separate judiciary from the executive. Okay, so remember this. Article 50 says that this separation of power from of judiciary from the executive. And Article 142, extraordinary power to Supreme Court to do complete justice. And Article 105 and 194, these articles give the privileges or state legislature or its members. And Article 122 and 212 prohibits courts to inquire into proceedings of parliament and state legislatures, which is 122 article for the Supreme Court and 212 for the High Courts. And Article 361, the protection of president and governors. So these given under Article 361 for discretionary power of the governor, but not constitutional discretionary power of the president, which are the situational power of the president, but governors has the constitutional power of the constitutional ordinance making power of the governor. Okay, so these are the discretionary power given under Article 361, which is constitutional for providing to the governors but not the president. President has the situational discretionary power of the president. And here important judicial pronouncements in context of separation of powers. So here the case Kesavananda Bharati versus Union of India, that the Supreme Court held that amending power of the Parliament is subject to basic features of the Constitution. So any amendment violating the basic features will be declared null and void, and it will be the unconstitutional. And next is the I.R. Coelho versus State of Tamil Nadu. This doctrine of basic structure as propounded in the above mentioned case and ninth schedule grant blanket protection to certain legislations from judicial review is violative of this doctrine. Ram Javaya Kapoor versus State of Punjab. And here the Supreme Court held that the Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of the different parts or branches of the government have been sufficiently differentiated. Next is the Kannadasan versus State of Tamil Nadu. The Supreme Court held the Constitution has invested the constitutional courts with the power to invalidate laws made by the Parliament and the state legislatures transgressing constitutional limitations. So remember here. Okay, and what are the way forward? Promote proper checks and balances between various institutions such as legislative, executive and the judiciary. And timelines in PLR projects limited versus Mahanadi coal fields private limited case, Supreme Court stated that recommendations by the collegium must be cleared by the center within 3 to 4 weeks to avoid any deadlocks. And promoting constitutional supremacy by focusing welfare of the citizens. So this is the separation of power is very important, and if you will want to access the lecture separately for the separation of power lecture, because this is a very thoroughly or comprehensive discussion will be needed, so it will be used very comprehensively, and I will make the video on this topic, so you can watch this video from my YouTube channel, so you can subscribe and then update your knowledge. Okay, next is the judicial activism and overreach. Why news? The Supreme Court verdicts in various cases rekindled the debate on judicial overreach and activism in India, that when judicial activism and overreach can happen when the center cannot take any deliberative actions given the right to the normal citizens, then the Supreme Court comes into the picture, and it seems and it works as judicial activism and overreach. And experts point out that the recent Supreme Court verdict on Section 153C of the Income Tax Act is an instance of judicial overreach. The Section 153C stipulates the conditions under which a search made on a person's premises could result in the opening of proceedings against other persons and entities. Supreme Court in its verdict has held that This section can be applied in retrospective, means the previous judgment or previous cases. However, experts point out that it is not an interpretation of the law but an instance where the law has been made by the judiciary. And earlier, the Supreme Court had passed judgment related to appointment of Chief Election Commissioner. While this judgment was appreciated for bringing in transparency in appointment process, some criticized the step as judicial overreach. So you can remember this. And understanding judicial activism and judicial overreach. It is a judicial activism is a form of judicial review in which judges participate in lawmaking policies instead of the government. Judicial activism is the use of judicial power to articulate and enforce what is beneficial for society. However, when judicial activism goes overboard, it is called judicial overreach. The distinction between judicial activism and judicial overreach can be subjective and often depends on one's perspective and the specific context in which it is applied. Okay, and what is the basis and what is the judicial review and judicial activism and judicial overreach? So these are the differences between these four terms, these three terms. And what is the basis? That is the goals and goals of the judicial review, to review the laws which are against fundamental rights. And what is judicial activism? For the goals of the judicial activism, that judicial activism vests or incorporates the power to overrule any acts or judgments or decisions or bring any reformations or any reform in the society. And judicial overreach, goal of the judicial overreach to undesirable in democracy, that autocracy is being increased. So judicial overreach comes into the picture and interferes with other organs of the government such as legislative action as well as executive action. And what is the intent or what is the performance of the judicial review or judicial activism or judicial overreach? Why in judicial review? What is the purpose? The review the validity of law under Article 13. If Parliament passed a law under Article 368, if this law violates or this law comes under Article 13, then Supreme Court or even if under Article 368 Parliament has passed any law which comes under Article 13, so automatically the law shall declared as null and void. And what is the intent of judicial activism? Use of judicial authority to enforce what is beneficial for the society. And judicial overreach, that tampers with the principle of separation of power and checks and balances. So remember this. An example of judicial review, the striking of section 66A of the Information Technology Act under the case of Anuradha Bhasin and suo motu cases, the introduction of public interest litigation. An example of judicial overreach, that striking down of National Judicial Appointment Commission, which was taken by the Parliament for the appointment of the judges of the Supreme Court. And arguments in favor of judicial activism, such as flows from Constitution. Judicial activism flows from the duty interested on higher judiciary, which is reflected in Article 32, 136, 142, and 226. So remember this. The judicial review is the power bestowed upon the judiciary by the Constitution to scrutinize legislative enactments and executive orders to ensure that they are in accordance with the provisions of the Constitution and addressing legislative or executive inaction. For example, in Visakha guidelines or Visakha versus State of Rajasthan, the guidelines for the protection of women at workplace from sexual harassment were laid down by the court due to absence of the law for the same, and protecting rights and liberties. In 1979, in Husainara Khatun versus State of Bihar, Supreme Court took up a public interest litigation action on behalf of the upper trial prisoners who had been in jails for a long time and promoting a social change. Judicial activism can set legal precedents that have a lasting impact on the society, nudging it towards progress. For instance, in Navtesh Singh Johar case in 2018, Supreme Court decriminalized of same-sex relations, and this under this case, Navtesh Singh Johar case, the same-sex marriage was legalized. Okay, and why it is criticized? Why is it criticized? The same seen as violation of separation of power. The judicial activism challenges the doctrine of separation of powers, which is part of basic structure of our constitution, and diluting balance among organs of the government. The judicial overreaching and increasingly interfering in the exclusive domain of the legislature and the executive creates an undesirable asymmetry, overlooking the consequences of judgments. In 2016, Supreme Court banned liquor sale at retail outlets that are within 500 meters of any national or state highway. The order was passed without factoring in the economic and employment consequences, and the judicial activism disrupt the policy making of the parliament. When courts venture into making policy decisions that are traditionally within the purview of the legislative or executive branches, it can disrupt the process of policy making and legitimacy of the government. Repeated interventions of courts can diminish the faith of the people in the integrity, quality, and efficiency of the government and judicial populism. Judges are human beings. Sometimes judges admit public interest litigation cases on account of raising an issue that is popular in the society. And what is the way forward? The judicial restraint. The principle of judicial restraint means that judges should refrain from the deciding legal issues, especially constitutional ones, unless the decision is necessary to the resolution of concrete dispute between parties. And it says that the judicial should invalidate actions of the legislature or executive only when constitutional limits have been clearly violated. And continuous evaluation. The judiciary should consistently assess and reflect upon the impact of its activism to ensure effectiveness and adherence to legal principles. And public awareness of civic engagement. When legislative and executive branches fail focus on public awareness and civic engagement rather than judiciary assuming their roles, strengthening democratic institutions. Instead of relying solely on judicial activism, efforts should be made to strengthen democratic institutions. So remember this. Okay, and here it is the method of judicial activism, which is static portion. So you can remember from your notes as well as from your standard book. Okay, and next is the legalized legislation. Why news? Recently, the Supreme Court observed that a delegated legislation which is ultra vires, the parent act cannot be given any effect. So here, what is delegated legislation? What is delegated legislation? It is a process by which executive authority is given powers by primary legislation to make laws to implement and administer the requirements of that primary legislation. So you can remember 2 to 3 times, then you can approach this definition of delegated legislation, and it is also important for the prelims for UPSC 2024 as well. Okay, so remember this definition. And parliament thereby through primary legislation enables others to make law and rules through a process of delegated legislation. Under Constitution of India, legislative power is given to legislature while executive has power to execute law. And due to improbability of time, the legislature limits itself to policy matters and delegating task of rule and regulations to execute or any subordinate to supplement parliamentary statute. And what are the issues in delegated legislation? Low scrutiny of delegated legislation because the Standing Committee on Subordinate Legislation in both the Houses of Parliament is required to study rules, seek expert and public opinion and submit reports to the House. And a study has shown that from 2008 to 2012, only 101 pieces of delegated legislation out of a total of 6,985 had been scrutinized by the committees, and frequency with which the rules and regulations are notified is very high. And for example, since Enforcement of Companies Act 2013 and under the Companies Act 2013 Act, it is also called as Companies Act 2013. Ministry of Consumer Affairs, not Commerce, Ministry of Consumer Affairs has notified 56 rules under the Act and issued 181 circulars. And against the spirit of democracy, as unelected person is involved in rules framing and political motive can also come in delegated legislation. And abuse of ruling making powers by executive failure to oversee delegated legislation can lead to abrogation and abuse of ruling making powers by the executive. And bad rules will inevitably lead to litigation and increase the existing backlog of the cases. And overlapping of functions, as the delegated authorities get work to amend the legislation, that is the function of legislators. What are the suggestions in reform of the delegated legislation? Parliament procedures must be amended to require the affirmation of every rule led through a vote. And additional working committees under a Standing Committee on Subordinate Legislation with legal and policy experts to help undertake a comprehensive study of all the rules placed in the Parliament. And these are the comprehensive suggestions that you can approach through listening my voice, okay, because it is very difficult to repeat or learn each and every point. So you can listen and if possible then you can pause the video and 1 time or 2 times you can read, okay. And next is the reasons for the delay. To draft the rules within 6 months from the date of commencement of an act must be mentioned before the committee. And coordination between member of parliaments and committees. If a piece of subordinate legislation is referred to the committee by an MP for an analysis on specific grounds, then it must be mandatorily undertaken and reported to the House in a time-bound manner. So remember this. Okay. And what are the purpose of delegated legislation? So remember this. Purpose of delegated legislation enables government to make a law without having to wait for a new act of parliament to be passed, reduces pressure on parliament, and decentralized and sector specific rule legislate regulation making, such as incorporate law. Tendency of lawmakers is to enact bare bone statutes such as SEBI Act 1992. So remember this. Okay, and next is the parliamentary privileges. What are the parliamentary privileges? Recently, parts of the leader of the opposition speech on motion of thanks on president's address were expunged. And before this taking forward, I want tell you that this is very comprehensive and time is very near for the means 2023. So I will read only and not uh, much forward the key concept of each and every keywords here. Okay, so if you want to know each and every keyword, then follow my YouTube channel, and as also press the bell icon so you can never miss update. Okay, so here I will only the read, and if possible I will tell you for important keyword. Okay, so here the parliamentary privileges. We are discussing the parliamentary privileges. What are the parliamentary privileges? A legal immunity enjoyed by the members of legislatures, in which legislators are granted protection against civil or criminal liability for certain actions done or statements made in the course of their legislative duties. And Parliament is the sole authority to ascertain if there has been a breach of privilege or contempt of the House, or no court is interested and the court is barred to this power or interference for the privileges of the Parliament. Okay, if the presiding officer gives consent, council can either consider the question and come to a decision or refer it to committee of privileges, a 10-member panel in Rajya Sabha and a 15-member panel in Lok Sabha. So remember these panels. Okay, and there are two types of privileges. Individual privileges, these are the rights that each member of parliament has in his official capacity. For instance, member of parliaments are free to speak their minds in the house. And the collective privileges, these are the collectively conferred privileges and are more generic in nature. For instance, right to publish documents and reports and discussions. Okay, and what are the sources of privileges in India? Constitutional provisions, these are given here under Article 105 for Parliament and under Article 194 for the State Legislative Assembly, with the powers, privileges and immunities enjoyed by the member of the Parliament and member of the Legislative Assemblies. Okay, and statutory provisions. The Code of Civil Procedure 1908 provides for the freedom from arrest and detention of members under civil procedure during the continuance of the meeting of the House or of a committee. And the third privilege is the privileges based on rules of procedure and precedent. Chairman has a right to receive immediate information of the arrest, detention, conviction, imprisonment and release of a member. Okay, and limitations of the privileges. The freedom of speech should be according to the constitutional provisions and subject to the procedures and rules of Parliament provided under Article 118 of the Indian Constitution, and Article 121 of the Indian Constitution confers that member of the Parliament is not allowed to discuss the manner and the judgment given by the judges of the Supreme Court and the High Court. No immunity and right could be claimed and held back by the members for anything which is said outside the proceedings and premises of the Parliament. What are the challenges associated with the parliamentary privileges? It would be against the natural justice, breach of privilege laws, allowing politicians to judge their own cases, raises concerns concerns about conflict of interest and violating fair trial guarantees, and legislators hold exclusive authority to determine breaches of their privileges and impose suitable sanctions for such branches against constitutionalism or doctrine of limited power. Absence of codified privileges gives unlimited power to House to decide when and how a breach of privilege occurs, and discredits separation of power, as the presiding officer acts as a complainant, advocate, and judge used as a substitute for a legal proceedings. So remember this. And why significance of the privileges or parliamentary privileges? Privileges help to maintain authority, dignity, and honor of MPs, and privileges protect the freedom of speech of parliamentarians and legislators, and privileges are effective functioning of both the houses and their members. So these are the significant. And way forward, the amending Article 19 Class 2 for the freedom of speech and expression. The expression contempt of legislature should be added. This course of action would remove some uncertainty from area, while at the same time houses would not lose its flexibility of approach. And committee of privileges should be given separate independent status, and committee headed by speaker or chairperson, as the case may be, should be empowered to decide and investigate the contempt proceedings. There should be a relaxation of rules against reporting of proceedings before parliamentary committees, and general principle should be that the proceedings should be open and reportable unless public interest clearly requires otherwise. And the conclusion is that a modern doctrine of privileges should not rely on an old stature whose main purpose was to assert Parliament's rights. A separate committee should be constituted consisting of members of Lok Sabha, Rajya Sabha, and the judiciary, retired or acting, to work on the codification of the parliamentary privileges. So remember this. Okay. And these are the codification of parliamentary privileges. The question of codification of privileges is very old. It was argued in concurrent Constituent Assembly regarding codification, but it was put it out on the ground that when a new situation arises, it will not be possible to adjust to the same need of the codification for consistent with the fundamental rights and judicial review, and remove arbitrariness in their applications. And arguments against the codification of privileges for flow to persons bent on defaming Parliament, and courts will be called upon more and more to intervene, such as recently in Rahul Gandhi case defamation. It would make the evolution of new privileges not possible. That here the Supreme Court recently dismissed or stay in case of the Member of Parliament Mr. Rahul Gandhi's defamation case. Okay. And next is the parliamentary productivity. Why news? Winter session of Parliament adjourned with Lok Sabha's productivity at 47% and Rajya Sabha at 42%. And recent instances of reduced parliamentary productivity or functioning. So here the if we see that the parliament is functioning is better, but it reduced its parliamentary productivity or functioning because of increasing the money bill as well as reducing the discussion among the members and its committees. Okay, so why this? Because absence of bill scrutiny. For example, hasty passage of National Bank for Financing Infrastructure and Development Bill 2021, Insurance Bill 2021. These were passed through the these were introduced through the money bill, and referral of bills to parliamentary committees. It has shown a declining trend with only 27% in the Lok Sabha and 11% in the 17th Lok Sabha, 27% in 16th Lok Sabha and 11% in 17th Lok Sabha. So here you can see that decreasing order, the parliamentary committees discussed the bills of parliamentary bills, okay, and reducing attendance. In 2021, average attendance in the Lok Sabha dipped to 71% and in Rajya Sabha to 74%. Like an actor which is who is the member of parliament, but his absence is the almost 100%. Okay, so you can understand yourself. Okay, not disclose his name. Okay, so here other reasons for declining parliamentary productivity, such as dissatisfaction in MPs because of inadequate time for airing their grievances, and sitting hours are not fixed by the constitution or rules of the house, and standing committees have anchored debates outside the house, and absence of prompt action against disruption MPs under the legislature's rules, and political parties not adhering to parliamentary norms and discipline their members, an unresponsive government, and the insensitive behaviors of the treasury benches towards opposition, and dissatisfaction in MPs because of inadequate time for airing their grievances. Okay, so remember this. And why it is important to ensure productivity or functioning of the parliament, because parliament has a central role in our democracy as the representative body that checks and balances the work of government, and parliament is expected to examine all legislative proposals in detail, understand their nuances and implications of the provisions, and decide on the appropriate way forward. To fulfill its constitutional mandate, it is imperative that Parliament functions effectively by imbibing the spirit of 3Ds, such as debate, discussion, and deliberations. And under Article 75 provides that Council of Ministers shall be collectively responsible to the Lok Sabha. Okay. And Article 74 mentions that every minister would be appointed by the president on the recommendation of the prime minister. A well-functioned parliamentary system in India must uphold the grounds of representatives' responsiveness and accountability. And how parliamentary productivity or functioning can be improved: increased number of sittings. National Commission to review the working of Constitution has recommended minimum number of sittings for Lok Sabha and Rajya Sabha should be fixed at, for Lok Sabha is 120 and for Rajya Sabha it is 100. and research support to members of parliament. Institutional research support will allow committees to examine issues that are technical in nature and serve as expert bodies to examine complex policy issues. And the committee referrals, requiring that all bills and budgets are examined by committees and extend the tenure of committee members so as to fully utilize their technical expertise on a particular subject in legislative work. And there is a need to formulate mechanism for regular assessment of committee performance. Responsible opposition members must question, object, and suggest alternative courses of action through reasoned and persuasive argument. And shadow cabinet allows for detailed tracking and scrutiny of ministers and assists MPs in making constructive suggestions and public feedback. A widespread debate over parliamentary functioning in the country must be undertaken by the government, which would encourage people's participation in the long run. Okay, and what are the consequences of reduced functioning of the parliament? Lack lack of lack of accountability of parliament. Okay, so remember this. And compromised legislative business, lack of avenues to express dissent, and rule of legislature disturbs the balance of power, and vacuum in governance that has been filled by an activist judiciary. Okay, and also can add in the weakness of the opposition. So remember this. Okay, an office of speaker. Recently there have been cases questioning the impartiality of the presiding officer, speaker, Lok Sabha speaker. Okay, so recently it is being seen that the presiding officer, that is the speaker of Lok Sabha, is taking a business cases. Okay, and who is the speaker of Lok Sabha? It is the officer of the Lok Sabha who is elected by amongst its members. So remember this only, and under article 93. So you can remember this, and it is a static portion, so you have to read your own notes and your standard book. Okay, what are the issues in functioning of office of speaker? Role under anti-defection law, and on declaring money bill and legislative proceedings. Okay, and allegations of partisanship and disruptions in the house. So you can read on your own, okay, from your notes and standard book. And what are the important judicial pronouncement in context of office of the speaker? So here case will be seen that Nabam Rabia case 2016, Supreme Court held that a speaker or deputy speaker facing notice of removal cannot decide disqualification proceedings against legislators. And Kisam Meghchandra Singh versus Honorable Speaker of Manipur 2020, Supreme Court held that decision under anti-defection law should be made within a reasonable time frame. And Kyoto Holohan versus Jasillu case 1992, a constitution bench, while upholding validity of anti-defection law, held that speaker's decision was subject to judicial review. Okay, and what are the suggestions to reform office of the speaker? Reduce role of speaker in anti-defection law. In Kisam Meghchandra Singh case, Supreme Court said that the current mechanism where disqualification petitions are entrusted to a speaker can be replaced by a permanent tribunal. and follow Britain's model. As per British convention, parties refrain from opposing the speaker during elections to uphold impartiality. And continuation based on performance. Page Committee, headed by V.S. Page, recommended allowing the speaker to continue in next parliament if they exhibited impartiality and efficiency during their tenure. Restrictions on the political office. It has been proposed that speakers should be ineligible for future political positions with certain exceptions while being granted a lifelong pension. And what is the conclusion? A watchful parliament forms the foundation of a well-functioning democracy. The presiding officers of parliament are the key to securing the effectiveness of this institution. Thus, it is important to ensure impartiality, fairness, and autonomy in decision making in the office of the speaker. So remember this, okay? And Lok Sabha and Lokayukta. Next is Lok Sabha and Lokayukta. Recently, Kerala Legislative Assembly passed the Kerala Lokayukta Amendment Bill 2022. What is all about the Lokpal and Lokayukta Act 2013. Lokayukta and Lokpal and Lokayukta Act was passed in 2013, and it is a statutory body of Lokpal for union and Lokayukta for the state. And aim of this act to inquire into allegations of corruption against certain public functionaries, including the Prime Minister. And Lokpal jurisdiction extends to Prime Minister, ministers, MPs, Group A, B, C, and D officers and officials of central government, and any society or trust or body that receives foreign contribution above rupees 10 lakh. And Lokpal consists of chairman and a maximum of 8 members, of which 50% shall be judicial members and 50% shall be from SC, ST, OBC, minorities and women. Remember this, okay? And chairman and members of Lokpal are appointed for terms of 5 years or until attain the age of 70 years, whichever is earlier. And Lokayukta shall have jurisdiction over CM, Chief Minister, ministers, and member of legislative assemblies, all state government employees, and certain private entities, including religious institutions. Okay, so here the need of Lokpal and Lokayukta. Lack of independent anti-corruption agencies and lack of transparency and internal accountability, inadequate mechanism to check corruption, and absence of effective power among bodies like CBC, etc. So here these are the need for the Lokpal and Lokayukta. But today we are seeing that these bodies are not functioning properly because ED and CBI are raiding to the states as well as the local bodies. Okay, and what are the issues associated with Lokpal and Lokayukta? Lokpal has not been given constitutional backing. Okay, so this is the statutory and not constitutional backing body, and there are no adequate provisions for appeal against Lokpal decision. Lokpal and Lokayuktas are not free from political influence, as the appointing committee itself consists of parliamentarians. Also, there are no criteria to decide who is a eminent jurist or a person of integrity, which manipulates the method of Lokpal appointment and delay in appointment. Earlier, India has appointed its first Lokpal in 2019 after 6 years of the Lokpal bill being passed due to the absence of a leader of opposition. And Lokpal suffered due to lack of human resources, curtailed budgetary allocations, infrastructural facilities, and delay in forming procedural rules to facilitate and process complaints. Lokpal has not appointed the Director of Inquiry and Prosecution, the two top personnel for looking into complaints of corruption and processing processing prosecution of accused public servant. And limited power act mandates that no complaint against corruption can be registered after a period of 7 years from the date on which mentioned offense is alleged to have been committed. And trust deficit in 2020-21, number of complaints before Lokpal dipped to 110 as compared to 1427 in 2019. Why this? Because of the role of ED and CBI, okay, ahead of Lokpal and Lokayuktas, indicates the institutional failure and trust deficit. What is the way forward? Lokpal and Lokayukta must be financially, administratively, and legally independent of those whom they are called upon to investigate and prosecute. Appointment of Lokpal and Lokayukta must be done transparently to minimize chances of political interference, and there is a need for a multiplicity of decentralized institutions with appropriate accountability mechanisms to avoid the concentration of too much power in any one institution or authority. And minority monitoring and ensuring protection of whistleblowers can be a part of the mandate of Lokpal, which needs a comprehensive statutory backing. And Lokayuktas should be set up in the state on the lines of Lokpal, with all state government employees, local bodies, and state corporations under their purview. Next is the anti-defection law. You can remember the anti-defection law is also a key term, is also important in the case of judicial system as well as the parliamentary system. Okay, so here it is very important. So, and also it is a static portion. Okay, so you can remember or read from your notes as well as standard book, and read this, the evolution of anti-defection law with thoroughly. Okay, and originate in the 1967, and it was the 10th schedule was knitted into the constitution. Only this you can remember, this only. Okay, not all about 52nd Constitution Amendment Act and the 10th schedule. It was given under the 10th schedule of the Constitution. Okay, so you can remember this. Here you can read this, the issues in the prevalent idea of anti-defection restricts freedom of speech and expression and reduces accountability of elected representatives and undermines representative government. Okay, so you can remember need for an anti-defection law. That why need of anti-defection law? To provide greater political stability by checking propensity of legislators to change parties and to ensure loyalty of members to political party and its policies, and upholds the will of the people, to facilitate democratic realignment of parties in legislature by merger of the parties, and to prevent non-developmental expenditure incurred on irregular elections. So you can remember. Okay, and read this thoroughly. Okay, and this you can read this. Okay, so here I will end the lecture. Keep watching, and thank you for watching this video, and have a great day.